Okay, before we get started, I'd like to welcome you all to another Index in Transformation seminar, and this is our second in-person one. Is that correct? So it's something to celebrate. This is and a very good turnout, and we're really fortunate to have Professor William Beinart with us. He's a fellow at STIAS, and he is formerly Rhodes Professor of Race Relations from 1997 to 2015, Emeritus Professor at St. Anthony's College and African Studies Center, has served as Chair of the Board of the Journal for Southern African Studies, been the Dean of the College, Director of the African Studies Center at Oxford, and many other things besides. And anybody who has studied South African history, sociology, anthropology has really learned. I remember when I was in first year, we read it second year, third year, and went on. And when you go through the list of publications, really important work, you know, most recently, a book in 2021 with Xolobeni called the Scientific Imagination in South Africa, 1700 to the present. A book with Corin Brown, African Local Knowledge and Livestock Health, and we'll read them through very quickly. A book with Colin Middleton and Simon Cooley, Wild Things, Nature and the Social Imagination. And most importantly, a book with Vuyo Wachela called Prickly Pear, The Social History of a Plant in the Eastern Cape. And the second edition of the book will be a book launch on the 30th of March at STIAS. And you're all welcome. I don't know whether it's up to me to invite you. I'm sure there's a lot of space and a lot of wine and whatever. But another extraordinary publication. And then the list goes on with a book with Marcel Dodson, the edited volume, Popular Politics and Resistance Movements in South Africa, and a range of books on environment, with Lotte Hughes, Environment and Empire, with Joanne McGregor, Social History in African Environments, and going back to the 80s, a very important book called Hidden Struggles in Rural South Africa, Politics and Popular Movements in the Transkei and Eastern Cape, 1890 to 1930. Another influential book that was really helped me when I was doing my PhD on land issues in Zimbabwe, The Rise of Conservation in South Africa, Settlers, Livestock and the Environment, 1770 to 1950, and numerous other books on with Xolobeni on segregation and apartheid, a book in 2001 on 20th century South Africa, and also involvement in school textbooks, A-level books as well. So straddling both the universities and the schooling system, and most recently really engaging intimately, actually over a long period of time, with land tenure and land rights. And there's a book called Rights to Land, a Guide to Tenure Upgrades. And then finally, another really important book that relates to what we'll be talking about today. Essentially, a lot of the research was done in Ponderland in the Eastern Cape. In this book, 1982, when I was doing my honors, a while back, the political economy of Ponderland, 1860 to 1930. So, yeah, one of South Africa's most interesting and important historians who's been ahead of his time, because he's engaging with environmental issues when it was not so fashionable way back. And as this continues, this interest. So thank you very much for coming to talk to us today. So we'll essentially have a a presentation 40 to 50 minutes. We can go on if you need a bit of extra time, then we have questions. Thanks.
Well, thank you very much. Can you hear me? Good, good. Stephen asked me to talk about issues that arose in some legal processes around land in the former Transkei and how I became involved. The research has been written up in an article in this edited collection, Land, Law and Chiefs. I have a couple of copies if anybody wants it. If you can assure me that you'll use it, even better, write a notice about it somewhere. Collections like this don't often get widely distributed. It's a pity, not carried in bookshops. But I think this one, as I hope I'll convince you from my talk, deals with important issues, not only for rural people, but for all of us. And among the many interrelated points, I'd like to focus on who has the rights to land in the former homelands of South Africa. They comprised about 14% of the land area of South Africa in '94, possibly 30% of people lived there, maybe even more, now probably less. Most of these rural areas of South Africa had and still have forms of customary tenure. But the question is, what is this? And who has the rights and who, quote, owns the land in these areas? To what extent are traditional authorities in control and asserting further control over land and related resources? And in fact, potentially expanding their authority, as much recent literature suggests. And what would be the best routes to secure the land rights of landholders who don't have formal title? And that includes, of course, people in informal settlements, as well as the customary tenure areas, and also on the roughly 10% of agricultural land, maybe 9 million hectares, a lot, that has been transferred. Complex issues which we've tried to, Peter Delius and I particularly have tried to write about in a short book and a series of articles. I'm going to talk about a narrower, so yesterday you had a wonderfully broad talk. This is going to be, I'm afraid, much narrower. 3 cases in Beinart district, now part of Alfred Nzo municipality. So I have great difficulty copying Google Maps. I don't know if anybody can teach me how to do it properly. Anyway, you can get some sense. So Beinart is the northernmost district of former Transkei. That's KZN, Port Edward to the north. This is the Umtamvuna River. And I'm going to be talking about this area more broadly, the coastal part of Beinart district, where 3 important court cases or legal disputes have taken place over the last roughly 10 to 12 years. Stephen did say, can I say a little bit about my background in this area? And I've researched on and off in the Eastern Cape over a long period of time. In fact, probably 46 years or something like that. And I'm very aware of the literature in development studies and anthropology and other policy-oriented fields that emphasizes the importance of trying to understand social relations in detail in any area before recommending policies or intervening. I visited this area perhaps on 4 projects over this period, starting with my doctoral thesis in the 1970s, which produced a book on the political economy of Ponderland, and then in the 1980s for a follow-up book, which was going to be on the Ponderland, or is going to be on the Ponderland Revolt of 1960, but I haven't finished writing it. Maybe in very old age I will get there. Then in 2008 to 12, a book on African local knowledge about veterinary, indigenous ideas, local ideas about veterinary questions, done with Karen Brown. And finally, in relation to these 3 court cases. But I feel that despite having some claim to a little knowledge about these areas, I've strayed from the maxim, the prescription, that one shouldn't be too prescriptive in what you recommend and how you, well, firstly, because you're asked to intervene in particular ways in court cases, of course, and secondly, because I've begun to formulate, again, largely with Delius, a clearer modernist view of agrarian and tenure futures. I'm not going to go into it in detail, but Africanists may find this uncomfortable in some respect because it tends to emphasize production, a critique of chieftaincy, and we're shifting or have shifted towards an argument for a single overarching registered, potentially titled form of landholding in the whole country, a uniform land. And of course, there are many proponents, both on the chiefly side and amongst populists, communalists, who argue that we should retain forms of communal customary tenure. So this edited collection is framed by 4 important developments in South Africa, which perhaps are at the edges of the national political debate, but I think are important. The first is the privileging of traditional leaders, chiefs in post-apartheid policy. The second is the whole question of customary law and customary tenure, and whether or not, I mean, this is protected, recognized in the Constitution, and I'm a proponent of the Constitution, but what are the implications of this through society as a whole? Thirdly, a shift in the economic significance of spaces that were formerly designated as homelands and reserved for African occupation only. They remain the poorest areas, but been very significant developments in relation to investment in mining, urbanization, expansion of small towns, spending power through grants, and transport routes. So just as one small example, this is the Wild Coast Sun, which I'll come back to, but so this is KZN along transport routes, Port Edward, a smallish town, but in fact, you could say that much of Port Edward is there in the communal land areas over the river, and in many places along transport routes, and with potential access to informal economy and jobs, huge concentrations of population are developing. Nobody's counted, this is all on customary land, not private land within the former Transkei. I wouldn't be surprised if there are 10,000 sites there now, people draining down from other parts of the Transkei into this area, and just an indication, one indication of what's happening in many parts of the former homelands. This has created intense demand for land, and of course this is mediated through political authority in customary areas, and that in turn has led to competition for office. And because of the nature of chieftaincy and customary tenure, these contestations often have a historical dimension, debates about legitimacy and custom. Partly because this then needs to be researched in many contexts, because strangely in a way, these debates often end up in court. Experts are drawn into researching questions. And our book is really based on colleagues who've had the experience of working with NGOs, with pro bono lawyers, in court cases, and sometimes in other contexts with communities. The approaches aren't uniform, but the contributors really trying to understand and support popular rights to land, resources, and political influence potentially from below. What scope is there? Political influence from below. We try to discern overall directions in policy and social processes on the ground. And it's difficult sometimes to understand what's going on and how to move up from the scale of case study to a national picture. And there are echoes in other parts, in other African countries. And I think it's very important to recognize that although these are amongst the poorest areas, people do have land, small areas of land, but land rights are significant, and land rights are significant in people's livelihoods. And if one wanted to translate them into a notion of capital, which we can talk about further, they also have that potential. My involvement in this latest phase of research in the area took place through these 3 court cases, which I'll call Hlolweni, Mgungundlovu, and Baleni. And the first 2 were long-running restitution cases lodged very soon after the 1994 Act by communities who felt, and we established, they were forcibly removed from their land. I was asked to give expert witness in Hlolweni in 2005 because the claimant's lawyers, led by Alan Dodson, a key, sometimes pro bono, usually pro bono land lawyer, found the book on political economy of Ponderland useful. And it was particularly useful because it had been written before the court case. So it wasn't that I had been called in simply to write an expert witness statement that supported the lawyers. It was there in a way already. I was also asked to make more general historical statements about Mpondo history and Transkei history, and I was cross-examined. It was an extraordinary scene. It was in the Tropical Nights Theatre in the Wild Coast Sun, which is here, where you can see Wild Waves Water Park, this casino, a huge theatre with about 600 seats, which was packed with people from the rural areas coming to listen to this key court case. And the case was about this land here in the Imizizi chieftaincy, now just beyond the area that I showed you of dense settlement. 10,000 hectares were appropriated by the Transkei Development Corporation in order to start a sugar plantation, and about 880 families were forcibly removed from that area. The sugar plantation was successful for about 20 years, up to roughly 1980 to 2000, but then ran into trouble for various reasons. And in 2007, there was a serious fire, which was probably intentional because the restitution case hadn't been settled over, it was lodged 10 years before, and everything seemed static. And it was particularly ironical that this took place at the Wild Coast Sun, because there was also a restitution case pending for the Wild Coast Sun, where people had also been forcibly removed. But they did, to an extent, cooperate, although they contested that case, as I'll explain. And among many of the legal and historical issues that arose in these cases were this critical question: who has the rights to land in these areas? Are they held by family heads, by families, or yes?
After it went down, did the people go back into the area?
No. No, in fact, sorry, I should have said, you can see that there's like a sharp cutoff point, and the community who have now been awarded this land, because these, of course, Google Maps is very recent, have been able to prevent settlement in this 10,000 hectares since the court case was decided in 2009. So it's grazing a bit of forestry, but we can come into that in more detail. I haven't moved back. It's a very interesting question. And yeah, so chiefs, local communities, the state, and do they amount to a form of ownership? And what layers of authority are there over different forms of land use? So these also proved very important in later cases that I was involved in, which I'll come on to in a second. Under the Restitution of Land Rights Act 1994, the lawyers needed to establish that the claimants were forcibly removed from their land, that this was done under racially discriminatory legislation, that the authority for this removal came from the Eastern Mpondo Paramountcy or King, Boertesikau, and the Transkei Development Corporation and the Transkei government. So you could say a black government, but the judge didn't accept it, saw that in a sense as a coercive government, not democratically elected. And the state had wide powers under various acts to implement such a removal. So the lawyers believed that they had to show that neither the Transkei state nor the Mpondo chieftaincy had the right to force people off their land for such purposes as a sugar plantation. There were smallholders too. And they had to show that it was racially discriminatory. Alan Dodson, who was the lawyer, thought that the Constitutional Court judgment in Richtersveld from 2003 set a precedent of kind and was applicable also to Hlolweni, this area. The Constitution provides that where customary law applies, it has to be taken into account by the courts, should the claimants or the protagonist wish it to be. And the court found, in relation to Richtersveld, that this part of the Northern Cape, when it was annexed, did not have its customary and indigenous rights to land extinguished, nor did the subsequent proclamations and legislation manifest an intention to respect land. Sorry, they did respect the intention to manifest an respect for land rights and not to extinguish them. And the Constitutional Court judges accepted this idea and proposed also in Richtersveld that this form of customary landholding amounted to a form, quote, ownership, and could be described as customary ownership. So they wrote that the form of occupation was akin to that held under common law ownership, and concluded that the Richtersveld community held ownership of the subject land under indigenous law. This was a very important case, because the key issue is, in a way, these are English terms. Of course, they're not directly translatable into the various languages under which customary debates may in part take place. But ownership in terms of the Constitution or Constitutional Court asserted a stronger form of right than, say, just custom, or in a sense, communal tenure. The term is often used, communal tenure. Dodson formulated his case then around the idea of communal indigenous ownership and wanted to establish this as the basis for African landholding in Hlolweni. And my evidence argued that the Pondoland Annexation Act in 1894 was analogous to Richtersveld. It didn't specify that land, the state was taking control of land or ownership of land. It was establishing administration, and the key early land proclamations all intriguingly specifically recognized earlier allocations. So they said, we recognize all the allocations of land that have been made up to the present, and that, we argued, was an additional proof, legal proof, that it wasn't the intention of the state to own the land. The claimants were able to show that coercion was used to remove them, and that the alternative plots they received were inadequate. And of course, that is one reason why this other area became crowded, because the people were moved from that empty space, Hlolweni, I'm calling it, that was just one of the villages, into this space. And Transkei state, we established, was coercive. And in the end, the judge recognized all this argument and awarded the land back to the claimants. It was really an excellent outcome, legally speaking, but much less so in practice. The judge didn't really develop the idea of customary ownership. He accepted that Richtersveld set a precedent, but Richtersveld were not in the former homelands remain unresolved and I think critical issues for the future of South Africa. Should we expect, I mean, I believe that, you know, many, in the second tranche of land claims under the 2014 Act invalidated by the Constitutional Court, some huge claims have been laid, and largely by chieftaincies. And, you know, is the state going to resurrect some of them, allow some of them? Are we going to which was the Wild Coast Sun case. It's a much smaller area of land. The dispossession took place at about the same time in 1980. In this case, there were 40 families settled there, 106 claimants because the families had fragmented to an extent. It was only 740 hectares for a casino, hotel, and golf course. You can just about see the golf course there. Hugely successful. We saw the turnover figures for the Wild Coast Sun between, well, that were in the court papers. And I don't know how much of it was profit, but the turnover was, because it drew down, as casinos in the former homelands did elsewhere as well, like Sun City. And Sun was a big global firm, although initially South African, it was very popular. We did quite extensive research on this case. I worked especially with Luvuyo Wachela, and the chair of the claimant committee, Elias Ogle, vice chair Zodwa Langazana. And the committee had a long-term connection with the Eastern Cape Land Claims Commission. But during the process between 2011 and 14, there was a split in the committee, which is not unusual, sadly. The office holders were thought to have benefited financially from their connection with the state and also from a private developer who had hoped that if they won the case, would develop additional eco-tourist resorts down on the coast. And as a result, they were ousted. There was another tension in, and again, this is not uncommon in claims, older people, especially older women, who were in their 70s and had seen the legal battle going on for 15 years, said, we're going to die before we get anything from this. And 30,000 Rand per family was on the table. Not a lot of money, but a bit more than a pension, so not insignificant for people who are living on that amount of money. And they ousted the committee and replaced it with another. And that hasn't been resolved to this day either. The old committee still claims that it has significant authority, and it's a long, torrid story as well. Alan Dodson was also the lawyer, and he wanted to be able to show that the families had been there from before 1913, that they'd been forcibly removed, a sort of time immemorial idea that, rather like Richter's felt, that this was old customary land, that they'd been forcibly removed and that there'd been successful peasant agriculture. That proved very important, and we did do 2 surveys, historic surveys of peasant agriculture. And the reason was about compensation, because if we could show that there had been significant agriculture, then it shifted the rate at which you calculated what could have happened in terms of earnings and income over the period, roughly 30 years, until the judgment. For this evidence, and later Xolobeni, which I'll come to, I tried to develop the section in the political economy of Ponderland that argued that land rights fundamentally lay with the landholder, with the landholding family, and not with chiefs and the states. Also, the issue of living customary law had come up before the Constitutional Court on a few occasions, and they'd begun to develop judicial ideas about this. It's a very complex area, which I won't go into. I don't know that much, sorry. I'm not a legal expert in any way, so I'm quite happy to be corrected. But part of the problem about customary law is that in the colonial era, it was often developed into codes and sort of set down, I wouldn't say immutably, but set down in a particular way that tended to reflect patriarchal authority in African society in the late 19th, early 20th century. And a number of lawyers were arguing that this, firstly, was not, quote, real or historic customary law, and secondly, that we needed to pay attention to what was happening on the ground, and that living customary law as a concept left a way out of having to depend upon a few old textbooks and the codes that were laid down in KZN and elsewhere. But of course, this puts enormous pressure on getting out to do the research. And is it the same everywhere in the country? Does everybody in a particular area accept one version? However, I did feel that the interviews we were doing, my own earlier interviews in the 1970s, Monica Hunter's Ethnography of Mpondoland, Reaction to Conquest, a survey that Peter Delius did, which argued that household rights to arable and residential land were strong. He didn't say they were ownership, but Budlander, a leading pro bono lawyer, made an argument in 1991, which in fact was picked up in that Constitutional Court judgment that I mentioned, that we had to move away from the notion of communal tenure and start to use the term ownership for customary land. And he drew on a Rhodes University-based lawyer, Alistair Kerr, who did extensive research. It's the only published book really on this issue until recently. And Kerr's reference point was a former Transkei, but he did again argue strongly. The chief is not considered as the owner of the allotted land. It's essentially, he saw chieftaincy as, in relation to land, as an administrative, having administrative functions. And such sites were generally handed down. They were hereditable. They weren't bequeathable. In other words, within African systems of inheritance, it wasn't as if a household head, when they died, could make a will and bequeath them, but they came down within the family, and they had exclusive rights over homestead and garden and arable land. I had additional motivations. So I felt there was a very strong argument now mounting up for a kind of living customary law argument for land rights resting within the household, that the household is the primary. And this, of course, was contested. I'll come on to that in a second. And I had additional motivations because by this time, we were formulating the book on rights to land, and we were shifting not only towards making an argument for family-based ownership of customary land, but also the longer-term idea that I mentioned of a single system of registered ownership. And the first would be potentially a significant precursor to the second. I have no influence in these debates. I'm just trying to explain the linkages that were being made in my mind as to the direction I thought would be valuable to go. But I did feel that our interviews, these weren't inventions. People, in response to the questions, affirmed a sort of popular notion of strong rights of ownership. And here, language, of course, is important. As it turned out, all this argument wasn't ever tested in court because after 2 days of site inspection and looking at our evidence, the Sun settled. And they had a difference with the first case as well was that they could get the best lawyers in the country and had very good lawyers. In fact, I shouldn't say all good lawyers come from Oxford, but of the group that collected in coastal Botswana down, the court case was going to be held not in the Wild Coast Sun, but elsewhere. 4 had Oxford degrees, believe it or not, South African lawyers. It was absurd, the amount of money and effort that was being spent on this case. But the government and the Sun resisted the restitution of this land, and they stepped down at the last moment. And the site inspection was very important because the lawyers arranged it brilliantly. They took around a group of everybody, including the judge, to key sites. We had gone in and identified where people had their land, and you could still see the old arable land and the graves. Sorry, yes.
How long did the case last?
Well, in a sense, it began in 1996. It was a claim. So I'm talking now 2013, 14. So it's a process of 18 years that it was had been going on. And that's why you get tensions as well, because restitution was sold in these sorts of complex cases, seldom directly. And particularly with one old 90-year-old man who had been a successful cultivator in his time. He was very eloquent. And then another man whose family had a land down on the coast next to the Mzamba River, just over here. He went into the ruins of an old homestead and plucked out a 3-legged pot and showed it around. And somehow that just captured the mood of well, you could see the judge was visibly moved by this. We don't know to this day whether he planted it there or whether it just was there. Anyway, and the community got a very, very good settlement. They got 90,000 per family. They got ownership of the land, ownership under a CPA. They got rental from the Wild Coast Sun, and they even got a small share in the company. And interestingly, they were not allowed to move back onto the land for 20 years, but they didn't really seem to want to because the potential, and this again raises fascinating questions about the notion of ownership. So does ownership just mean your family land, or does ownership also mean a much broader concept that you can own as a CPA or trust, as you can legally, of course, but that the community has internalized this as a form of collective ownership as well. But there wasn't therefore a decision on the issues that I wanted to come before the court, which was prioritizing the landholders' rights to land as the critical thing. And it still hasn't been tested. I need to tie up now. So, in effect, I think what's happened, if we look at this from the vantage point of living customary law, is a new localized hybrid system of land allocation administration. The old permission to occupy system has collapsed largely, not everywhere equally. I can go into that in more detail. That was the old government allocation system. Most land is now not allocated by senior chiefs, but allocated by communities in working with headmen. And it seems to me that this reinforces the kinds of arguments that I'm trying to make. But in the Baleni or Xolobeni case, the state, again, the state and the chief, sorry, let me start in a slightly different place. The state gave a mining license to an Australian company to operate in this area, to mine ilmenite and titanium. So going back to the general point that things are changing rapidly, partly because of the location of minerals in these rural areas. And this is natural, this red soil. It's not, vegetation just doesn't grow there. And it's because of the geological composition of the soil and its richness in particular, the other minerals as well, potentially quite valuable. However, the community formed a group called the Ahmediba Crisis Committee under Nonhle Mutuma, which has become a national, even international sort of campaigning group. And initially they were not necessarily just against mining, although they did try to defend against the mining license on environmental grounds, which they lost with a Cape Town lawyer. So the mining was going to go ahead, but it was about who controls, who is going to, and 128 families were threatened with removal if this mining was to go ahead. And yet they were not given any rights to control the mining company that, and in fact, as you probably know, the Minerals Act of 2002 and subsequent amendments and whatever governmental edicts requires that there be 26% Black economic empowerment ownership in any new mining development. But this so often works through the chiefs, and in this case too. So this case was, yeah, Lunga Baleni, the Ahmediba chief, based over here, became one of the personal BEE beneficiaries, not simply as, in a sense, holding shares for a tribal authority, but personally was going to benefit from it. And I think this divided the community hugely, but it's replicated in many different places. Bafokeng, Bakatla, BIPO, especially in the rich mineral lands of the Platinum Belt in Northwest Province. And we were seeing a replication of the same process over here, which helped to mobilize the rural community. So the state expert witness on customary law claimed that, who was appearing for the chief and the state, argued that the landowners only held their land as lawful occupiers. And we tried to use these earlier judgments and also evidence on the ground to make the argument about ownership, that they held this land as customary owners, and that made all the difference as to who should consent and not only be consulted. So another very interesting aspect of this case in 2018 was the difference between consulting and consenting. And we've managed to establish, at least in this judgment, that the judge, Dodson, felt that not only was this potentially a form of customary ownership, but also that consent was necessary and not just a consultation. Because the mining company, the state, as you might know, Greater Mantashe is very committed to this mining going ahead. The ANC argues, well, you know, in the homeland area period, the National Party refused to allow capital into these rural areas. Now we want to get them developed, and environmentalists and other do-gooders are coming along and saying, well, you know, but in fact, this case, I think, is different. It is true that there are environmental groups linked to but the resistance is coming from the grassroots, and it's about who holds the land, who owns the land. So they failed in an earlier bid to stop the licensing on environmental grounds, but in 2018, the case came to court in the name of the 128 landholders, supported by their sub-chief, which is another. So a sub-chief related to Baleni asserted independence from Baleni. A headman, in fact, argued that this was in effect a chieftaincy, and that that community as a whole was resisting the mining. Because there's not much time left, I want to leave time for questions. I won't go into the details of the judgment. I can explain it to you, or try to explain it to you in more detail. But a critical element was an act of 1996 called EPILRA, Protection of Informal Property Rights Act. And the judge believed that it was valid in this case. It hasn't been much implemented, and so the recognition of EPILRA in contradistinction to the rights given in a mining license is again a major judicial development, which can potentially empower other rural communities. But critically, EPILRA is defensive legislation. It doesn't specify what rights the community or individual landholders have. It only specifies a defense against expropriation, if you want to, or removal from their land. There's been some attempt to legislate in this sphere, but the Communal Land Rights Act of 2004 was overturned by the Constitutional Court in 2010, partly procedural, but also because there were strong objections to the powers given to traditional authorities under this act. There's been a consultation since 2017 attempting to legislate again what is the nature of customary rights in land. Agreement can't be reached, and it's around these fundamental issues that I've been talking about. I won't say this with a great deal of confidence, but it does seem to me that the ANC has accepted that chiefs will be a major pole of power and authority in the rural areas. And we see a sequence of legislation that supports it. And we see chiefs having significant control over parliamentary select committees, in parliament, even in the executive. Nevertheless, yes, sorry. Should I wait, or can you hear me at the back? I'll shout. I'm finished now. So again, something we can discuss in more detail. The courts, interestingly enough, in a series of judgments in Northwest, particularly the Constitutional Court, but other courts, but the Constitutional Court Bakhatla judgment removed support from the Bakhatla chieftaincy to try to stop popular meetings being held in their area. There's been another case in the Ciskei, two cases, in fact, in the Ciskei recently, which have reinforced communities' rights to elect their own, quote, headman, depending exactly on how you define that, but against the chief's rights to appoint headman. And I think we're seeing as well in the Land Court judgment of 2009 and other judgments, a gradual movement within the constitutional courts and some lower courts towards the protection of landholders' rights to land, as opposed to state chiefs and others' control over the land. These seem to me very important, but still unresolved issues, and I'd like to hear your thoughts about them.
Thanks very much, William. So let's take 3 questions or comments at a time, and we do have more than enough.
I've got a question. With regards to community claims on land, how much does that include immigrants, migrants, and refugees? Because it very much seems that landholders who've got a claim to land have got a historical stake in it. So how much does that community include those who don't have historical stake in the land and are there before others?
Do you want to
you choose.
Respond, and then we'll have more questions later.
And it is a thorny issue and a difficult one. And I would say so all African communities have, over long periods of land, had mechanisms to incorporate foreigners. Of course, in the area that I've worked in, marriage tends to be exogamous, and so women come into and patrilocal, women tend to come in from outside into a community. So in relation to that fundamental aspect of society, strangers, if you want to, are incorporated all the time. But this area is particularly interesting on the boundaries of KZN and Transkei, because historically, southern KZN was quite late colonized and quite late developed into commercial farms. But when it did begin to happen, we found in our interviewing that a significant number of the people who lived in these coastal communities traced their family background to further up the coast, KZN, which wasn't entirely convenient for us because, of course, the lawyer had asked us to find people who'd been for time immemorial. Nevertheless, we were quite explicit in our reports. There were a few key families who'd been there for a long time, since before 1894. So that process, those processes have happened in the former homeland areas. And of course,
RET practices perhaps, or the pushing down, whether these things are being reopened, and whether the ANC support chiefs is a question, or whether it's just in solid genealogy from, say, the 1990s where decisions were made. So I'm curious about that aspect. And also, of course, whether where you ended the seeming and pending tension between where the Constitutional Court is pushing and where the ANC is pushing. So just to elaborate on that.
Thank you so much. My name is Mgungundlovu from the department. My question is slightly irrelevant, but very passionate. Yeah, I'm very passionate about this. So my question is on the relationship between customary law and mining. I've been reading the same court judgments with fascination. It seems to me, and quite recently, the seismic survey against Kenya, it seems to me that environmentalists and communities have built so much power at court to the extent that mining will somehow become impossible in the near future in communal areas. So, for instance, in many judgments that I've read, judgments from 2007 onwards, many court judgments emphasize the importance of customary rights, or what is called intangible cultural heritage, something like that, and the importance of sustainable development and climate change and all that, and consultation. So, in one of the major constitutional court judgments, I think it's in 2007, the judges actually say that merely speaking to a traditional leader does not amount to consultation, which means that you then have to entertain all the complex nature of customary rights and all. So does that imply that in the near future, mining in communal areas will be difficult? That's what I'm trying to argue in the paper that I'm writing on environmental. Yeah, thanks.
Should we have one more? Two. And please introduce yourself.
Yes, I'm Dumi. I'm from this department. My question is rather, forgive my ignorance, is there a legal definition of land? Because when you think of land, I'm thinking of property most often, not necessarily space, some sort of space. So is there a legal definition of land? That's it.
There's so many points that have come up. I don't think, if I were to try to answer them all, well, firstly, I'm not sure I can, and secondly, it would probably take the rest of the time. So, in answer to your point, there is a highly developed legal or set of legal definitions and prescriptions about land in South African statute law and Roman Dutch law. So, the answer is yes. And if you look at something like Kerr, although there hasn't been enough writing about it, also some significant writing about land, but what I'm not sure about is what you mean. When you say land, you're distinguishing it from property. And I expect most of the legal arguments and legislation is essentially about property, including customary property or customary rights, rather than about land per se. But of course, land potentially has so many different elements, minerals, water, all of these linked and subsidiary rights. You could say vegetation, wildlife in some ways as well. All of these things potentially come into it. And each has got legislation surrounding it. And as you probably know, water legislation in South Africa has changed significantly. Forestry legislation has changed quite significantly, but they tend to be, the discussion of them legally, as I understand it, tends to be separate rather than anybody, to my knowledge, attempting an overarching, that I may be wrong, an overarching view. And then, so why has the ANC gone with the chiefs so much? And Cheryl, I'm sure you probably know a lot more about the Ngonyama Trust than I do, but I think that the critical thing was that at that particular moment when Mandela needed to persuade Buthelezi to come into the 1994 election, what was Buthelezi asking for? And it was the recognition of the Zulu king, and it was the Ngonyama Trust were two of the key elements. There are probably other elements which I can't now just recall. And so I don't think that for Mandela and for the ANC at that time, the importance of getting this election going and the settlement, threatened as it was by potential far-right people and internal conflicts of other kinds, that I'm sure that they didn't fully think through what the implications were in the longer term. However, those who write about Mandela do say that he had a propensity to honor chieftaincy, at least. I think at that stage in the ANC, there was a clear distinction between a kind of more cultural role, more customary role, and local political power. And there was the intention to develop, and it has been developed, a fully democratic and elected local government system, which operates in all the areas of chieftaincy as well. But in fact, the chiefs had 40 to 50 years in the Bantustan period of consolidating authority. There's a good historiography about all of that. And we need to understand that they didn't come to the 1994 settlement, as it were, from a standing start. In some areas like former Transkei, they'd been heavily attacked and partly ousted. Nevertheless, in many parts of the country, they still had significant authority and some respect in some places. So that's, and understanding this as a process from below, and as you know, Contralesa, other organizations identified with the ANC, and there was a switching of position. Some chieftaincies had been more over long term associated with the ANC, and some switched position. And the ANC, it seems, especially in, so it's interesting, it's Thabo Mbeki we think of as our most technocratic and modernist president, probably in retrospect, aside from Mandela, most successful president. He passed the 2003 Traditional Leaders and Governance Act because I think, in part, there was a necessity to recognize the longevity and the influence of the institution. At the same time, and there's quite a lot of writing about it, I've never really seen a convincing argument about it, that the ANC came to perceive that its rural vote depended, or at least was connected with chieftaincy and the support of the chieftaincy. Now, in fact, it's interesting that the rural districts and provinces have consistently returned higher percentages of ANC MPs than others. But I don't know, what is chicken and what is egg here. I think we're talking about complex processes of assertion from below, erosion of other forms of local government, which we now can fully grasp. It happened slowly. I think there was a period when the Sanko people who had been so critical of chieftaincy and moved into local government and looked like something else might emerge, an alternative democratic form of local government. But that hasn't been realized in many parts of the country. So I'm not giving you an answer. I'm just kidding. And I mean, the 2019 Traditional and Khoisan Leaders Act seems to me to open up things even more. So these acts, by and large, don't give chiefs particular powers. They are enabling acts for traditional councils and chiefs, but they're dependent often on other acts to say that the chief will act in, or the traditional council will act in this context. They specify how traditional councils should be constituted and that they need to be constituted in a more gender equal and in a more democratic way. But there are many examples in the book where, in fact, on the ground, that hasn't really happened. So I expect what I'm trying to get at is that this new act may not in itself provide great new powers, but there's a critical clause which I'm not sure the implications of have been fully recognized, and that is traditional council in a particular area can devolve rights over development and land to private or outsiders and private enterprise people. Now, whether that was possible before or not, I'm not entirely sure. And Bafokeng suggests that in some ways it was. It did happen. That had its roots in the former homeland period, where a corporation could be developed through a chieftaincy and traditional council to actually control a major economic enterprise. But this now seems to have been facilitated by the new act. And I've just seen a few cases where it seems to be happening. One of them, in fact, again, is on the Pondoland coast, so don't be surprised if another court case comes up where a Chinese company has offered the Western Mpondo King significant, let's say, I don't know what they've been offered. I'm dependent on Kevin Bloom's journalism largely for this. But for the lease of 10,000 hectares on the coast around Port St. John's for a range of new developments. So it does seem to me that this new act actually potentially opens up further that nexus, which we've seen materialize most effectively in the Bafokeng example. And the question then is, who are the beneficiaries? And whether ownership of land, and this comes back to my key point, gives you the right to consent. Because if that goes ahead, it's very unlikely that there will be consent by so many owners of land or occupiers of land for such a development. And that's why I feel this legal nexus around land remains important. Land as property. So, sorry.
We have time for one or two more questions or comments. Yes.
Thanks very much.
Please introduce yourself.
It's Thomas Erickson, University of Oxford. I'm also a fellow visiting there. Yes. So there were some. You spoke a bit about the way in which the arguments for land redistribution of land had shifted over the last few decades. And I wonder if we're not seeing a global pattern here towards a culturalization of arguments, not least among indigenous groups, where in the past, in the 1980s, say, the main arguments were about the right to land and water, and because they've been colonized. This was also the case in northern Scandinavia with the Sami, the reindeer herders. But increasingly, especially since the turn of the century, we have heard the cultural arguments. We relate to the land, to nature in a different way. We have a different cosmology, ontology, etc. And for that reason, we should be granted full rights over this land. And you've seen something similar taking place here. I wonder if you could comment on that shift.
Yeah, no, it is an interesting and important question. I would say there are different strands, and it's difficult to know which one is emerging as the most significant. So the Khoisan leadership Act, this 2019 Act, specifically recognized Khoisan people as potentially having similar leadership rights. And of course, this has been translated into land claims as well. Some, like the one I recently visited at Ebenezer in the northern part of the Western Cape, essentially are not, at least as far as I can see, are not operating through an ethnicized or a cultural identity. They're fundamentally about forced removal in 1926 to establish a poor white irrigation scheme, and they've just won their land back. That case took from 1996 to 2020 to work through. But there are other claims going on. I don't know enough about the details, so yes. Then there's another angle to it, of course, is the Komarov's suggestion of a connectivity between, let's say, commercial interest or material and cultural, and how these two things work together in various contexts, and they give very interesting examples. I think in South African politics, more broadly, there is always this tension. On the whole, I think that the ANC works very largely above ethnicity. In other words, still with a discourse of rights that are not essentially regional and ethnic. Within that, of course, there are interests and perceived networks and accusations about regional interests, and often regional, I think, as much as ethnic. So it's a bit like the answer to the question on outsiders and foreigners. There's so many different contexts. Sometimes in South Africa, do get mobilized. And I mean, I've just seen, sorry, this is just, it's too big a question for me to try to answer fully, but RDP houses have always been sold, but there's a new anxiety that they're being sold. And it's a state, essentially houses that come from the state and then sold. And it seems to me that this sudden new anxiety is essentially about foreigners as well. It is a perception that foreigners are buying RDP, and poor people are selling houses that they got from the state by reason of being South African citizens and having that right to foreigners. So that seems to me a kind of diffuse aspect of what you're talking about, but more at a national level than at the level of somebody saying we are claiming this land because we are Zulu or because we are, Sepedi in a particular place. There's so many layers of identity formation and cross-identity politics that I would be cautious about saying that we're getting an overall shift towards identity politics as shaping land debates. We certainly, identity politics do seem to be everywhere, and that does seem to be a phenomenon of the global phenomenon of contemporary society. But I'd need to think harder, and it's an important question, I think, like the foreigner question, that needs to be worked through. And no doubt there is a bit of literature, but I can't put my finger on it right now.
Yes, thank you. Yes, I think they're related, and also what you mentioned about the commercialization of identity.
Yes.
From largely political identities to increasingly commercialized identities in some respects, and also the contrast which has been posited by some scholars of urban Africa, especially between what the French-speaking part of Africa, they speak about autochtone versus allochtone. The autochtone are those who've always been there, and the alloctones are those who came from outside. And why did this suddenly become relevant in the 1990s when it had never been commented upon before? That's the question we need to ask.
But they've had taken other forms in earlier periods. And no, it is, of course, fundamental to British political debates as well. And Theresa May formulated that as the people from somewhere, the people from nowhere, of whom I'm one, proudly.
I think also, are there any final questions, guys? Okay, I mean, Mzi also made a comment based on close reading of the court judgments about cultural heritage. You mentioned a whole range of things, intangible cultural heritage, customary rights, climate, sustainable development, all entering, am I right, into the argumentation and the judgments. And that also has a kind of international precedent to it, and the ontological turn finds a space, and we don't yet have the ideas of the rights of nature in our judgments, but it's sort of slowly edging there and drawing on indigenous cosmological ideas. You can find, I'd be interested. I don't know, once you can find.
Answer very briefly.
Please do.
I'll try, and I know I talk too much, but so 2 points. Just on the environmental issues, it seems to have been the weaker route for community defences in a few situations recently. It's difficult to defend against, say, mining developments. But just at the moment, the arguments around land rights seem to me to be winning out better, whether through appeal, because there were 2 cases around Pilra recently, and the courts seem more attentive to and accepting of those. But I may be wrong. Dinesh Gosana has a chapter in this book in which she sort of argues slightly inversely that in this case it was Glencore, the very large, originally South African but now global mining company that overrode heritage in the shape of graves, and argues that the heritage legislation in the country is too unspecific and not sufficiently oriented towards intangible heritage, too connected, and again, to sort of property, specific types of buildings which have a certain kind of legislative protection. So, I mean, that is a very interesting point. And the question that you raise is, will this inhibit mining? Thus far, I don't think that it has to a great degree, although, of course, this case on the Wild Coast, and there's also a case on the West Coast, may begin to get mining companies to think. But I think their concern, if you read what they are saying, it's far more about the BEE legislation and the attempts by the Zuma government to expand it to 30% with other requirements about ownership than, in other words, about property relations, rather, I think, yet about heritage. And just one further example. So Ipilra failed as a defense by a community for Mogalakwena when that huge platinum mine was first started. The community did bring a case, and the judge overruled them. I think 2006, Potgietersrus was mining, something like that. However, interestingly, because it remained a sore point, Anglo-American, who owned the mine, did appoint a kind of commission, historians, to go and look at what had happened and to try to see if it could be resolved. And I think that they have succeeded in doing it, no doubt through money. But in that case, very similar to what I've been talking about, a chieftaincy accepted the development, but the 2 villages whose land was appropriated didn't, because they didn't get, they were considered as part of the chieftaincy. And in that case as well, it might be interesting to look at it and to see if heritage issues came into it, or graves. Graves are often cited as and I think graves are metaphorical. Cheryl may have other ideas, but are often metaphorical in the way that they enter into these debates about land rights, heritage, and so on. I'm not saying they're not important in themselves. They are, but they assume, because they have a physical presence and they're associated with death and ancestors, they develop a very strong sort of metaphorical route or into the discussions.
Thanks very much, William. I mean, it's fantastic. I mean, we seldom encounter historians who shift from the archives to the contemporary in such powerful ways, and also link us in the Western Cape, we sometimes think we're a separate homeland here, and link us to the Eastern Cape, which I'm from, so I really enjoy it. Yeah, no, an extraordinary sweep of concerns that are often not in our minds, and the media does not cover these rural areas sufficiently. And so thanks very much for bringing these issues to us and making them so alive. And just to remind you, and this wasn't on my list, there were a number of books when I introduced you that somehow didn't make it onto the list. And so the book launches on the 30th, and the title...
So no, not for that one.
Oh, not for this one. But this is a recent one as well.
It is, yes.
Yes, this is 2021.
I'm actually offering copies of this one.
Okay, I'll take this.
2 here.
Land, Law and Chiefs in Rural South Africa, Contested Issues and Current Trends. Thank you.
Sorry, I don't have more.
And the book launch is?
The second edition of Brickley Code. You might say, why was there a first edition? Why a second edition? But I hope to convince you on
yes.
the 30th if you were to come.
Yes. I'll do it.
Of course. But if you want me to order a copy, unfortunately it's $4.20. It's terrible. It's so costly.
One of the things I was thinking about is whether social